Well, good morning, everyone. I know that people will be joining as we do the opening and as we talk. This is being recorded, so people can tune in if they wish to. They can rewatch it, and I assume many people who've put their name down will have done that. But don't worry if you're a little bit late. My name's Ben Williams. I'm a member of the Employment and Regulatory team in Chambers. Dr. Nathan Smith is accompanying me. He's going to talk second. I'm going to give you what I hope will be a helpful overview of GDPR. When Nathan and I spoke about how best to deliver this, we thought that you benefit from an overview in the first instance, and then perhaps bringing that into a relevant arena, because many of you will be litigators. I know that many of you will encounter GDPR in all varied ways. What we thought would be helpful is I'll give you an overview of some of the ways I've encountered it through my position as a regulatory team member particularly, but also in the employment team. And then what Nathan will do is draw on some specific cases, which I know you'll find extremely helpful and illustrative in terms of approaches or otherwise. So GDPR, it gets bandied around a lot. People will just repeat that acronym, and many people don't seem to me to know what it is. I encounter that a lot in employment litigation. I encounter a lot of people claiming there are GDPR issues when in fact there perhaps aren't. But what is it? Well, General Data Protection Regulation is what it of course means. It's legislation that governs the collection and use or misuse of personal data from individuals inside the European Union. It's been adopted into UK law. It mirrors EU GDPR, but the relatively new UK GDPR is nearly identical to that. But it is independent British legislation that is enforced through our UK data protection agencies. And it doesn't influence the European Union. It's about, as I said before, the use of information. It's about how information is collected, stored, and then used in a variety of ways. And what you would understand to be data, so typically names, addresses, email information, identification cards, passports, and the like. That's fairly straightforward. That probably doesn't take anyone by surprise. But it can also include something perhaps more discrete. It could be location data. And we, in this new age, all understand with our mobile phones how that might work. And you get the option to sign in, opt out of various ways in which social media, for example, Instagram, Facebook, might track what you're doing and how you're doing it. It could also be photographic footage. It could be film. That could be CCTV. I'm going to speak shortly about how I've dealt with GDPR in the context of CCTV in other various ways. What I think is important at the outset is perhaps to tell you what the 7 principles are, because those 7 principles enshrined in the legislation govern everything. As with many examples of legislation, there are the underlying objectives. Sometimes they are written into the legislation. Sometimes one just simply gleans them by the very nature of that legislation. But GDPR does enshrine 7 principles. I'm going to tell you what they are. I don't expect you to recall these, and you don't need to, because they're straightforward and they're there, and you can get your hand on these to help influence any piece of work you're doing in relation to GDPR. The first, perhaps one of the more important, although they're all of equal importance, of course, is lawfulness, fairness, and transparency. By lawfulness, that's the lawful basis for collecting and using the data. And then really it's about being open and honest in the way you do so. So there needs typically always to be a lawful reason for taking data and using it. And that can come up I'll tell you in a few moments about a drone footage case I've been involved in where lawfulness did come up because they wanted to know whether it was even lawful to do something in that way, whether it was legitimate. The second principle is about purpose limitation. You've got to be clear on the purpose for which you're keeping the data and not to use it for other purposes. Of course, I don't think there'll be anybody on this talk watching and listening in who haven't had nuisance phone calls, which is largely about data being shared amongst various companies, particularly when it comes to PPI or diesel emissions seems to be in vogue at the moment. The third principle is about data minimization. You've got to limit to that purpose limitation. You've got to take steps to make sure it is so limited, because there is the potential for it to drift into other arenas. Then the fourth principle is accuracy. Make sure that the data you hold is accurate. Make sure it's not misleading. I've come across this in the context of criminal records being kept, or certainly where we've come across incorrect information that is being stored, and then the individual is highly susceptible to adverse consequences. For example, when job applications have been made and they've not understood why it is they've been rejected at first instance. It's because incorrect information is being held about them. The fifth principle is storage limitation. That's about keeping it for no longer than you need to. And that's an important point, because I think a lot of people fear that information is being kept for longer, and often it's in the fine print when you sign up as to how long that will be kept. As lawyers, we understand the concept of keeping information for a set period of time. But in the context of GDPR, there is no necessarily set period of time. It may differ from one context to the next. The sixth principle is to act with integrity and to act with confidentiality. These principles seem to me to be pretty straightforward and obvious things to have enshrined. But it would mean, from a practical point of view, that you should have appropriate security measures in place. Now, many of you work for companies. Some of you may well be self-employed. Whether you work for a company or you're self-employed, this will apply to you. But security measures, I have seen the way in which Chambers has caught up and surpassed my expectations about data security. And we've got various measures now as we're more and increasingly remote to deal with that, because everybody is susceptible to phishing attacks, to hacking. The final principle is one of accountability. And that, of course, is important in terms of taking responsibility for what you do with the data. And that is that accountability that if you fail, because the accountability is really about doing those things in numbers 1 to 6 and doing them properly. And if you don't keep records about what you're doing and how you've done this, then you can find yourself in hot water. And when I say yourself, of course, this is largely going to be your clients who are going to come to you, usually after a problem has arisen. But I very much hope you can encourage them to come to you far in advance of that. And there's a lot of work that you can do for them. I don't think people appreciate just the amount of work that should be done. But as the years have passed, people have caught up. I've seen an increased quality in privacy notices. I used to draft privacy notices way back. I've done less in recent times as people just adopt and use other notices that they think are helpful and maybe tender them to their own circumstances. But when it comes to the principles, your clients need to have regard to those. You need to have one eye on those when you're advising them. And the reason you need to do so is because there's all manner of ways in which things can go wrong. There's all manner in ways, particularly if your client is storing lots of information, that information can fall into the wrong hands, or can be lost, or can be merged and confused. And your clients need to take steps and need to do so in a transparent way to ensure as best as they can that that doesn't happen. Not every problem results in a complaint. Not every complaint results in a further complaint or a cause of action through the courts. I know Nathan's going to talk about that, where it does go wrong and where it has gone wrong. I'd just like to very briefly talk to you about the Information Commissioner's Office, because I have been involved in a number of cases where a problem has arisen and the client, through solicitors, have asked, what do we do about it? How do we broach this? And I immediately, in all those cases, have in mind the seventh data protection principle, one of accountability. And I immediately want to think about whether they self-report, but I absolutely want to ensure they get ahead of the problem. And there's a real fear that that perhaps they're inviting problems to the door. But in my experience, going to the Information Commissioner first, much like self-regulating professionals going to the SRA, self-reporting the Bar Council, it typically, in fact, I think always plays out to your advantage. The way to scare clients into action is to remind them, perhaps cautiously, that substantial fines await if things go wrong. There's been some high-profile cases about substantial fines, Uber being one of them. But just to remind you what data protection and GDPR tells you is, and it's Article 83, it basically says that fines can be up to £17.5 million. Of course, that's dependent on the size of the company, or 4% of your annual worldwide turnover, whichever is higher. These are substantial penalties enshrined in the legislation. And I've represented American-based companies who are, of course, extremely concerned about that because their turnover was huge, but and the problems were this side of the Atlantic, but they wanted to know what their potential liabilities were. And they were quite surprised by me telling them what GDPR said, particularly as the rules in America are rather different. I said I'd talk to you about the source of work, and that's where I'd like to just spend a few minutes. We all perhaps are experienced in GDPR impacting the litigation process. I know in the context of employment that it is being used, brackets misused. I think claimants, often litigants in person, are making subject access requests ahead of the date for disclosure. They're trying to squeeze the employer. They're trying to make sure that they cause maximum embarrassment early doors. And this is particularly problematic if there are emails or documents that we don't want the claimant to see. And we're hoping to perhaps settle a case in advance of the date for disclosure. And this just brings that date forward. It also comes up in terms of bundles for the litigation process and what may be included or what ought to be redacted or not. GDPR says in the context of subject access requests that the individual has the right to personal data, and they have the right to exercise it easily and at reasonable intervals. They can exercise it more than once, of course. And they also say that the individual needs to know how they go about that or how they may make such a request. And it's often for the employer in the context of litigation to deal with that. The reason why DSARs, as we know them, become rather alarming in certain instances is because the timeframes are quite tight. Your client would have 30 days to respond. You can get an extension of up to another 30 days, but really you should be working to that 30-day limit, and the extension would need to be done in a very clear way with clear reasoning. Otherwise, you might face some criticism. And that, as I say, is quite alarming to clients because the litigation process is maybe running alongside that. It may be pre-litigation, and it's often quite difficult to manage such a process. Bigger employers have dedicated teams that deal with it. Smaller employers really are required to do that work themselves. And if it's a bad time of the year, seasonally, then that can cause a huge amount of distress, as I've found in some cases. But in terms of other ways work might come to you, it's not just about perhaps assisting your clients in DSARs. Think about how policies, I talked about privacy notices, but policies may be drafted. Policies about data, policies about dealing with information. The other ways it might come is website management. I've talked to you about hacking and the principle that requires you to take such steps to ensure that perhaps data is not abused or misused or taken from you, which of course is what hacking can do. I've dealt with a case about cookies. You probably all know what cookies are, the pop-ups, and there are people out there going around various websites checking that the cookies are accurate and when they're not, bringing various claims, and it's become rather a career for some. But what it does expose is that despite the fact you might click your data is not to be used or not to be used beyond what you're looking at, sometimes those cookies don't quite work in the way you would want them to, whether that's by design or by default. The other ways in which I get involved typically are inadvertent passing on of information. One of the common problems, and we perhaps all suffered this as there are various namesakes, is you suddenly get an email. I've had one recently and I thought, why don't I know about this case? Why does it mean nothing to me? Now, that isn't always an alarm bell. There are that many cases that go on. Sometimes I don't recall them. But then you would later find that it was meant for a completely different Ben Williams. And there are three of us at the bar. Fortunately, there's a Benjamin, but there is another Ben Williams. I like to think, although younger, perhaps the inferior of the two. Please don't pass that on. But ultimately, that is potentially a data breach. That could get you into a spot of bother. You can try and recall it. You can certainly take steps to minimize that. But I've dealt with a number of cases where solicitors have been concerned that this might be an SRA issue where they've sent on some quite sensitive information inadvertently. And the use of predictive emails ought really to be turned off on most systems. That is an obvious step to take. If it is not, then of course you're going to struggle to justify what has happened, even though it was unintentional. Said before, the use of CCTV or drones, that is another common one. And so I've been asked, for example, to advise on the disclosure of certain CCTV in the context of litigation, people wishing to sue for a catastrophic incident in a sensitive venue, I'll say no more. And they didn't want to disclose this for fear of revealing the identities of others there. And the obvious answer to that was to simply get somebody in to blur out those faces so that their personal data, their image, was not being shared, something they just hadn't thought about. The drones one I was just telling Nathan about, it was quite an interesting one in that drones were being used to survey land for the purpose of putting up wind turbines. And that's typically done by the human beings, but they thought they could short circuit it and use drones. And when I said before, the first data protection principle about lawfulness, that was really what was concerning them. Are we even allowed to do this, was the question. The answer was, of course, yes. There was some legitimacy. There was a lawfulness in what you were doing, even if it could be done in other ways. And the expedient use of that meant that that was entirely legitimate. Of course, there are all sorts of implications in terms of accidentally capturing data that might happen as those drones flew around. And what that type of scenario revealed to me is that there were gaps in privacy notices, there was gaps in policy, and it also enabled my instructing solicitor to get involved with an impact assessment. Now, that they can be done by third parties, but ultimately impact assessment can be quite an important tool that I'm sure you could all advise your clients upon to minimize the risk that may ensue from a particular type of situation. Those are the ways in which it may impact your clients. There are very many other ways. In terms of, and I'll leave it with this before I pass on to Nathan, in terms of perhaps the most common encountered problem is the issue with hacking or phishing, PH. I learned lots about how that might work. I hadn't appreciated that there were different types of phishing, spear phishing, where things are targeted. And I've been involved with a large employer who were the subject of a spear phishing attack, and it lay there for some period of time. They were completely unaware until a sweep of the system discovered it. It revealed all manner of weakness in the systems, which was potentially problematic. And it certainly revealed the importance of transparency, because I can tell you that that client got ahead of the issue, project managed it through the legal team, and we were able to manage that in such a way that the ICO, who we thought would be extremely concerned and interested, and we thought might result in some fines, it did not. We also thought it might result significantly in all manner of third-party claims. And again, fortunately, it did not. Now, some of that is by luck, but I like to feel that a lot of that was because it was managed in the appropriate way, even though a problem emerged that perhaps shouldn't have had the systems been appropriately maintained. So there we are, all manner of ways it might impact. Bit of a broad brush explanation of what GDPR is, and forgive me because many of you will know exactly what it is. And what I would also invite you to do off the back of this talk, having heard myself and Nathan, is if you do have queries, don't be afraid to run that by myself, Nathan, or the clerks in chambers. And between us, we can always offer some guidance in the hope that we can assist. So thank you very much for listening. I'll pass you on to Nathan.
Thanks, Ben. So I'm going to talk about claims for compensation that individuals can consider bringing when there's been a breach of the UK GDPR. And I've got some slides, so just bear with me. So as you probably know, under Article 82 of the UK GDPR, any person who's suffered material or non-material damage as a result of an infringement of the regulation has the right to receive compensation from the controller or processor for damage suffered. Subparagraph 2 draws a distinction between the liability of controllers and processors, but it's important to bear in mind subparagraph 3, which provides a potential way for a controller or processor to escape liability, but is quite restrictively drafted and places the onus on the controller or processor to prove it's not in any way responsible for the event giving rise to the damage, which can be quite a high threshold. Section 168 of the 2018 Act is also relevant, should be borne in mind, because it makes clear that non-material damage also includes distress, whether or not there's a financial loss associated with it. Now, nothing in Article 82 prescribes the level of compensation that a court may award, so that's a matter of national law. But it's worth bearing in mind when considering cases relating to Article 82 that ECJ, European Court of Justice decisions, while no longer binding in the UK, can still be taken into account too. Now, I'm not going to talk about European law today. I'm going to concentrate on a few UK decisions that talk about these types of claims. And I think probably one of the most well-known cases is the Google and Lloyd case, 2021 UK Supreme Court decision, handed down in November 2021. I think this case actually concerns Section 13 of the 1998 Act, but it's equally applicable, or the principles are equally applicable to Article 82 of the UK GDPR. Now, a bit of background to this case. According to the claimant, Google had been secretly tracking the internet activity of some Apple iPhone users and sold that data that had been collected without their knowledge and consent. And relying upon GDPR 19, the claim to represent everyone who was resident in England and Wales who owned an Apple iPhone at the relevant time. Also argued that it was unnecessary to assess the compensation that was payable to each potential claimant because compensation could be awarded for loss of control of personal data without the need to prove any financial loss or mental distress had been suffered as a result. Another complication in this case was that Google is based in the US, so to get the claim off the ground, the claimant needed permission to serve the claim from out of the jurisdiction. And that's what this case is really about, albeit it discussed the wider principles around these claims. And the High Court initially refused permission to serve outside the jurisdiction. Court of Appeal reversed that decision, and the High Court reinstated the High Court decision refusing permission. Now, for our purposes, the interesting point is that Section 13 was held to provide for the payment of compensations to any individual who'd suffered material damage or distress, but the damage was something distinct from unlawful processing. So in order to recover compensation, an individual has to show not only a breach of the requirements of the Data Protection Act or UK GDPR, but also that some material damage has been caused, whether that's financial loss or mental distress as a result. In other words, there was no claim simply for loss of control of data if there was no pecuniary loss or distress associated with it. Now, of course, the range of circumstances and cases that data protection legislation can apply to is fairly wide-ranging. But I think one area that that I've dealt with, and I think in the commercial arena is quite interesting, is the potential for claims against companies by their customers. Not so much where the company is doing unlawful processing as part of its business, which I'm not going to talk about, but where there's a data breach either caused by a cyber attack or some sort of accidental loss of data. And I picked a few cases that illustrate the sorts of claims that could be made in these scenarios and how courts have approached them. I think the first one to be aware of is Warren and DSG Retail. In this case, DSG, a well-known retailer operating brands like Currys, PC World, Dixon's Travel, was subject to a complicated cyber attack between July 2018 and July 2017 and April 2018. Judge Court said it was carried out by sophisticated and methodical criminals, and that seems to be fairly accurate because it involved infiltrating DSG systems and installing malware running on over 5,000 point-of-sale terminals, which allowed the attackers to access the personal data of many customers. The case did go to the Information Commissioner as well from a regulatory standpoint, but in the civil courts, Mr. Warren, one of the claimants, had purchased goods from Currys PC World and claimed that his personal data, that's to say his name, address, phone number, date of birth, had been compromised in the attack. And as a result, he sought damages of up to £5,000 for distress as a result of his personal data being lost. Now, the claim wasn't brought just for breach of the Data Protection Act, but also for breach of confidence, misuse of private information, and also in negligence. And in June 2021, DSG applied to strike out all of the claims except for the breach of statutory duty under the Data Protection Act. And the judge did strike out the misuse of private information claim on the basis that there was no positive action or use by DSG to complete the tort. And the judge gave the example, which is quite a good one to bear in mind, I think, in these types of claims, when they're framed as MPI type claims, of a burglar that comes through open window and steals someone's bank statements, saying it made little sense to describe this as a misuse of private information, because there was no positive action or use by DSG. The judge also held there were two fatal problems with the negligence claim. First, there was no need to impose a duty where the statutory duties under the Data Protection Act operate. And secondly, there was no damage suffered in any event that was recognised by the tort of negligence. Anxiety falling short of recognised psychiatric illness not being sufficient. So the MPI and negligence claims were struck out, and the remaining claim was transferred to the county court for directions. So the case is an example, I think, perhaps in the early days of this type of litigation, of how attempts to complicate claims under the Data Protection Act by adding further causes of action are often not successful. And also how, in most cases, Data Protection Act claims, if they are going to be pursued, are more suited to the county court. Second case, Stadler and Curry's Group Limited. Now, Warren, of course, was a case of a third-party cyber attack. Stadler was a case where the breach alleged was an omission. It's quite interesting factually. I think the claimant in this case purchased a smart television from the defendant in September 2016, which allowed him access to third-party apps, one of which was Amazon Prime. In September 2020, he returned it for repair. He wasn't asked to remove or clear any of the apps off the smart TV. He didn't log out his Amazon app or any other apps before leaving the TV with the defendant. You can perhaps see where this is going. The defendant decided it was disproportionate to repair the TV, so offered to write it off and give him a voucher, which he accepted, thinking the TV would be destroyed. It was then sold to a third party without wiping the data. Then it transpired in December 2020, a movie was purchased for £3.49 using his Amazon account through the smart TV. Now, the defendant reimbursed the cost of the purchase and gave him a voucher for £200 as a gesture of goodwill. The claimant still issued a claim for up to £5,000, relying on misuse of private information, breach of confidence, negligence, and breach of the data protection law under Article 82. The MPI and breach of confidence claims were struck out following Warren. The negligence claim was also struck out as there was no remaining loss that fell within the tort. The judge still refused, though, to strike out the GDPR claim and said that while it was unquestionably of low value because it arose out of a single incident, he said it was nonetheless disproportionate, and indeed said it was disproportionate to allow it to continue in the High Court. Still allowed it to continue, transferred it to the County Court with a view to being allocated to the small claims track. One of the reasons being that claimant's bank details were also alleged to have been stored on the smart TV. The next case, Smith and TalkTalk. This is another case involving a cyber attack. A claim was issued in August 2020 on behalf of Graham Smith and a number of additional claimants. The defendant, of course, a well-known telecommunications provider. Again, the claims were for breach of statutory duty under the Data Protection Act, damages in tort, as well were claimed for misuse of private information. Perhaps unsurprising, that second part of the claim was struck out, but the judge did allow an inferential case under the Data Protection Act to proceed. And I think this case is probably an example of the courts being applying a principle in effect that the court should be less inclined to strike out claims or summary judgment or enter summary judgment against claimants when they don't quite know what's happened until disclosure's taken place. But again, the lesson seems to be that if you are bringing a claim under the Data Protection Act, it's better to concentrate on that cause of action, at least unless the requirements for another tort are clearly made out. So I'm just going to talk about a couple of cases from this year before I finish. The Farley and Paymaster litigation. Now, this was a decision, the first of these was handed down in February of this year, a decision of Mr. Justice Nicklin. And in this case, the court was required to determine applications brought by over 400 police officers of Sussex Police for breach of the GDPR and or the Data Protection Act. And there was, in fact, a claim for misuse of private information, and it did actually survive the summary judgment or strikeout process in this case. So it's still there to be considered in some cases. In any event, the defendant was the administrator of a pension scheme to which the claimants belonged. It had sent to each scheme member an annual pension benefit statement that contained the member's name, date of birth, national insurance number, and details of their salary and pension details. Unfortunately, the statements were sent to out-of-date addresses due to an error in how the address details were stored. The claimants contended that the sending of the statements to incorrect addresses was a breach of UK GDPR and also a misuse of their private information. Now, the judge held that to have a viable claim for MPI or data protection breaches, each claimant had to demonstrate a real prospect that their pension statement had been opened and read by a third party. And without that, he said there was no prospect of demonstrating a misuse, which was an essential element of the MPI tort. And there was also no prospect of demonstrating a claim under the data protection legislation either. So the judge separated the claimants into different categories. Firstly, those who'd received their statement unopened. Secondly, those whose statements had not been safely returned and who relied upon an inferential case that their statements had therefore in fact been opened. And thirdly, those who advanced a positive case that statements had been opened and read by a third party. And the judge held that those in the first category could not advance a claim on the basis that until their data had been returned, their data was at risk or in danger, because the law did not allow recovery for apprehension of a tort that might be committed. A near miss was insufficient, and that applied equally to both MPI and Data Protection Act claims. The judge also held that those who relied upon an inferential case also had no real prospect of success, as absent some facts that would compel a different conclusion, a court would not draw an inference that a letter marked private and confidential had been opened by a third party. Where the claimants were able to advance a positive case, though, and that was actually quite a low number of the total, those claims were permitted to proceed to trial. Now, another point to note about this decision at paragraph 159 is that the judge said it was not necessary nor desirable for him to reach a concluded view on the very interesting point as to whether the law in this jurisdiction imposes a threshold of seriousness in data protection claims, which the judge thought would be better resolved at trial given the potential importance of the point. If there is a threshold of seriousness in English law, then that would be a point of divergence with EU law following a decision in May 2023 last year. That decision, though, by Mr. Justice Nicklin is not the last word in this area, because permission to appeal against the decision was heard by the Court of Appeal in July of this year. And the question for the court was whether the High Court was wrong to treat the claim as turning on proof that anyone had read the personal data in question. The appellants didn't seek to challenge the judge's order as it applied to the MPI claims, but did in respect of the data protection claims. And as I said, the first ground of appeal, which is the relevant one in this context, is whether the judge was wrong in law to hold that in order to have a viable claim for infringement of data protection rights, the applicants needed to allege and prove that the letter was opened and read by someone. And the Court of Appeal granted permission to appeal on this ground and said at paragraph 15 of the judgment that in principle an individual may establish that personal data has been processed in breach of their data protection rights without proving that the information or data has in fact been read or communicated to anyone. And following on from that, at paragraph 16, cases in which non-trivial harm is caused by processing of this kind, falling short of disclosure in the sense contemplated by the judge, may be rare, but it cannot be said it's impossible as a matter of principle. So while we still don't have the decision on appeal, it seems at present at least there is still a risk of a claim, even if an envelope marked private and confidential is sent to the wrong address and returned unopened, albeit the individuals would still have to satisfy a court that there was in fact damage in each case if the matter ultimately proceeds to trial. So what do I take from all of that? Well, this is still an developing area of law. And secondly, it's important to bear in mind that Data Protection Act claims cover a much wider scope of situations than I've discussed here. And the ones that I've focused on, as I say, mainly relate to companies where there have been accidental breaches or they've been subject to cyber attacks of some sort. Now, while some group actions have been unsuccessful, some are still pending, the Farley case being an example. So I think watch this space to see what happens and how that develops in the future. In any event, what the cases do show is that there's a real risk of individual claims where damage can be shown by individuals to arise as a result of unlawful data processing. And of course, that can include distress without any financial damage, albeit in many cases, you expect those claims to find their way to the county court rather than the higher court. So that brings me to the end of my section of the talk. And if Ben wants to say anything further, but thank you for coming today. Like Ben said, if you do have any queries, do feel free to try and get in touch. And I hope you found it useful. And we'll let you get on with your morning. Thank you very much for coming.
Thank you all.